Welcome, everyone. My name is Sarah Ray from the Bloomfield Public Library. And we welcome back Attorney Jeff Rivard today as we learn about trusts. So I'm going to turn the mic over to you.
Thank you, Sarah. Thank you, everybody, for coming. Hopefully you can hear me okay. So as Sarah said, my name is Jeff Rivard. I'm one of the attorneys at Sapega, Daly, Pope, and Perry. I am normally in our Bloomfield office. Just really quickly about us, we are a kind of a boutique law firm. We do a lot of estate planning and elder law. We do a lot of trusts. We're sort of very purposely not a general practice law firm. There are people out there that kind of do a little bit of everything, and we're happy to say there's all sorts of things we don't handle, but hopefully you might, consider us with expertise in those areas. Some quick housekeeping. This presentation is in listen-only mode. That means you're stuck listening to me, but I can't hear you. If you want to try to ask questions, sometimes I do tend to kind of respond to those along the way. There's a chat box that I think is on the right-hand side of the screen. If you throw in questions, I can try to tackle those as we go along. Sometimes I'm buried under questions and we just can't get to them all. And other times I get no questions from anyone and I'm not clear if anyone's still awake. So maybe along the way, we can sort of turn it into a little bit of a dialogue, if you will. So as far as trust, clearly in an hour, we're not going to cover everything there is to know about trust. But what I think we can do is help you kind of understand that when it comes to trust, it's not one size fits all. Not every trust is like other trusts. I think back somewhat amusingly that over the years, I've met with new clients many times, and sometimes people will say they need a trust. And then when I say, why do you need a trust? I get all sorts of reactions. Sometimes they'll stop and they'll say, well, my parents had a trust, therefore I need one. Or my favorite is, well, we were at the place in Florida and we were talking to the neighbors. They said, oh, you got to have a trust. So at the end of the day, I think we don't necessarily appreciate that what a trust is as far as estate planning. It's really sort of a tool in the toolbox. And when you look at a toolbox, there are various tools, different sizes, different features to fix certain problems. So what we're going to do is we're going to talk about different types of trust and some of the characteristics, the way in which we can sort of think of them as tools. And some of the characteristics of the types of trust we're going to talk about are very similar. Sometimes we say, well, that trust has the same characteristic as this trust. Other times they're very different, and we have different purposes in why we're setting them up. So that's sort of why we're going to kind of think about what are sort of the common things you see on all trusts versus the ways in which some of the trusts we're going to talk about seem very different from one to the next, if you will. So pretty much every trust, I think we could describe thinking of this triangle, this little visual aid, a triangle, three ends. So the top pointy part of this triangle says, who is the grantor? Who's the one that put the wheels in motion? Who created this legal arrangement? Generally, that's our client. Sometimes we run into a situation where somebody who's not our client has already created it, but somebody has created a trust along the way. Now, what is a trust? Let's even get more simple now. What is a trust? Well, this little green box says a written document that provides for the management of your money. Well, it's a little hokey, but I think even more simplistically than that. Let's picture a situation where you are about to hire somebody as a babysitter or maybe a pet sitter or a house sitter. And you say to this person, hold on, before you decide whether or not to take the job, whether you want me to hire you, or what I'd like you to do is go into the kitchen and look in the refrigerator, because I've typed up a very detailed list of written instructions. Those are my rules of the road. The gate in the backyard has to get closed. The kids have to be in bed by 9. The dog gets the prescription from the vet and doesn't get the people food, whatever it is. There are your rules and regulations for how you want your house, child, pet looked after. Well, this babysitter, if they take the job, essentially they're a trustee. They're agreeing to be entrusted with certain rules and responsibilities according to your list of instructions. That, in essence, is what a trust is. So in my little example, I'm the grantor, you're the grantor because you're the one who's typed up your rules and regulations. And the person who's agreed to take the job, they're your trustee. So look on my triangle, the bottom left, we have a trustee, the person who's agreed to follow the instructions. And then the third end, bottom right on our slide, who are the beneficiaries? For whose benefit have you set the arrangement in motion? Now, one of the things you're going to notice here is for some kinds of trust we create, all three of these prongs are the very same person. Other times, this may be three different people or some combinations. But if you think of this structure, pretty much every trust we can think of as far as asking who's created it, who's going to be following the instructions in that agreement, and for whose benefit are those instructions going to be followed. Okay, so as far as kind of basic mechanics, one thing we can ask about is this an arrangement that is being created that is in place right now while I'm alive? It already exists. Here's Jeff, alive and well, and over here is Jeff's trust I've already created. Versus a type of trust that I might create that really doesn't exist yet until after I have died. And the kind of trust that only exists after I died is something that I will write into my will. So in my last will and testament, which is why you'll see this term as we put in the slide, we call that a testamentary trust, as opposed to a living trust, something I've created right now while I'm alive. Now, whether or not I've retitled assets so my trust owns particular assets, that's actually kind of a slightly different question. But suffice it to say, I may have reasons to create a trust that doesn't exist until after I have passed versus the kind of trust that exists right now. What are the distribution provisions? Well, that note on the fridge, what does it say? In the case of this living trust, that's going to be a trust agreement, something the grantor who's created the trust is going to sign, and the trustee is going to sign because they basically saying, yeah, I agree to take the job, and I know what my instructions are because I've signed this agreement. It's almost like I mean, we don't normally think of a trust as a contract, but it's almost a contract because the trustee is agreeing to follow your instructions you've provided. And specifically, when we talk about distribution provisions, it can sometimes, and in a few minutes, you'll see what I'm talking about. Sometimes it's just as important when the instructions tell the trustee what they can't do. Sometimes that's just as important as telling the trustee what they can do. And some trusts are extremely detailed. I may have 8 different pages with all the little nitty-gritty details about under the circumstances, trustee can pay for this, but not for that. Other times it may be very brief. It may be only a couple of sentences. And the third prong here is who is the trustee. This can be sometimes, with some clients, this is an obvious decision. Sometimes it's not at all obvious. Sometimes we have multiple choices, but they're all kind of bad choices. You know, maybe I have 3 or 4 different people in my family, they all have problems. We're trying to figure out what's my best bet here. But suffice it to say, we're thinking about somebody who can serve as the trustee. So, different types of trust. Well, we can start with perhaps the simplest to understand, which is a revocable living trust. Now, not every living trust is revocable. Some trusts are irrevocable. But 99% of the time, if you hear somebody say, oh, I have a living trust, what they mean is a revocable living trust. They won't say a living trust if it's irrevocable. So what does that mean? Well, it's extremely flexible. As we say in our first bullet point here, while the grantor is alive, they can change it as much as they want. They could sign the trust on a Monday, and on a Tuesday, they could come back, Attorney Rivard, I was thinking last night, I think I made a mistake. I shouldn't be giving my nephew 5%. I should have given my nephew 7.5%. Can I do that? Absolutely. I can help you file an amendment. And then Wednesday, you come back again, change my mind again. My nephew has not been making commonsensical decisions. I don't think I should leave anything to him. Can I take him out? Sure, we could do another amendment. So it's very flexible. And it's going to stay that way until the grantor passes away. As soon as the person who's created the revocable living trust has died, now nobody can make any more changes. And by definition, it becomes irrevocable at that point. Now, what are some things that a revocable living trust are good for? Well, they are good for avoiding probate. Why might you avoid probate? Well, if this was in person, I could have sort of taken a poll of the audience. But if you've had the pleasure of dealing with the probate court in any recent times, probate courts tend to be slow and frustrating. They're cumbersome. Sometimes dealing with probate gets expensive. So a lot of people would rather avoid that. So a revocable living trust can be a good strategy for that. It really shines in particular for a single unmarried individual. Perhaps somebody who is a widow or a widower, and now they own their home, but they're the only owner of the home. And the way probate works, Connecticut, like many states, has a formal probate and an informal probate. And anytime we have solely owned real estate, we have one living person on the deed, that automatically triggers the need for the whole process. So a revocable living trust can be a good strategy to avoid that, because you sign a trust, you sign a deed, and now we have a trust agreement that's going to say what happens to the property after we die. We don't need to go through a court process for that to happen. People may not necessarily appreciate this, but one of the downsides to probate, at least a full formal probate process, is a lot of what happens in a probate process is public information. Nosy neighbors, if they want to try hard enough, can go down to the probate court and figure out what you owned, at least as far as what your probate estate looks like. We avoid that if we have our assets in a trust. It may be the case that nosy neighbors will learn you have a trust. How do they know that? Because if they look at the assessor's property card, they may say, did you see that Mary across the street created a trust? Because the new owner of her trust is the Mary Smith Revocable Trust. But that's all they know. They don't know what the trust says. They don't know its terms. They just know that it exists. So it can be a very good tool for privacy, even with your own family. I'm saying revocable, nosy neighbors, but sometimes the worst of the nosy neighbors is our own family. I have 4 kids and I get along with 3 of them, but one of them, we're oil and water, and I don't want him to know anything about what I own after I die. Well, a revocable trust might be a very smart way to do that. Okay, so keeping things out of prying eyes is another good use of a revocable living trust. The last bullet point, the topic of today is not specifically estate planning, but when we talk about basic estate planning, kind of estate planning 101, it is a good idea for everybody to have a power of attorney, somebody that can help take care of your financial affairs if you become incapacitated. And it's also a good idea to have somebody you've named as healthcare representative, somebody that can make healthcare decisions for you. Well, the nice thing about the revocable living trust is the way we tend to write them, they'll kind of go in order and they'll say, while I'm alive and well, here's what happens. And if I become alive and unwell, here's what happens. Maybe if I can't continue as trustee, I've named someone else that can take over for me. And then if I'm married, I might say, if I pass, but my spouse survives me, then what happens? And ultimately, once we're both gone, then what happens? So my point here is disability planning. It can be a good strategy to rely on the notion that if I'm a single person, I'm not married, but if I become incapacitated, I have a stroke. If my assets are in a trust like this, I will have language that's going to kick in. It's going to fairly seamlessly say, now my son's going to take over for me, helping use my money in my trust to pay my bills. So it's very flexible in that regard. But it also is going to have language that says what happens after I've passed. And in that way, the trust also looks a little like a will. A will is a document that only speaks once I've passed. The revocable living trust has got kind of a foot on either side of this river. It's covering what happens if I'm alive but incapacitated, but at the same time, it says what happens after I pass. So it's got a lot of flexibility there, okay? So that in a really quick nutshell is a revocable living trust. Now, if we have a married couple that has a lot of money, specifically when I say a lot of money, what I mean is around 4 to 5 million or so, given the current limits. Their language sometimes couples will use to help avoid estate taxes. A lot more of our clients aren't worried about estate taxes because we don't have that many millions of dollars, but sometimes people do, and that's another way we can use these. One last point before we move on. If you happen to own real estate in another state, particularly in your individual name. Mom died 3 years ago. She lived on the Cape. You have a nice cottage on the Cape, and it's only in your name individually. That can be a very bad way to own that property, because basically what would happen is if you pass away in Connecticut, not only will your family have to deal with probate court here, but now if you're the sole owner of a property in another state, like Massachusetts or Vermont or Maine or Florida or wherever, they'd have to deal with a second probate court. They would need to get appointed fiduciary in that other state. And that's exponentially more expensive and frustrating. So the very same revocable living trust you create here in Connecticut can be a very good way to avoid probate in that second state. So that's kind of a real quick whirlwind over from sort of my toolbox analogy, what sort of issues can get solved with a revocable living trust. Now, shifting gears for a moment, we talk about a special needs trust, special needs trust. Now, this is the first example where what the instructions say the trustee can do, it's almost as important as what the trustee cannot do. So why do we need a special needs trust? Well, for starters, we have a trust designed because we have a beneficiary who has disabilities of some sort. It may not always be that they're on government benefits right now, but it may be, given what we know about their health and the trajectory, we anticipate it's foreseeable they will probably need government benefits. So a special needs trust is a very specific technical type of a trust where the trustee is obligated to use the money for the sole benefit of our special needs trust beneficiary, our disabled beneficiary, but in a way where it should be invisible to the government, to Medicaid, state of Connecticut, whoever's providing the benefits for this person. Now, this slide and the next one are two somewhat different versions. We have a first party versus a third party. What does that mean? First party, as we say in the first bullet point here, is an arrangement that is funded with the disabled person's own money. Somebody gets in a terrible motorcycle accident, they end up paralyzed, there's a lawsuit, there's a settlement, a bunch of money's paid out, but at the same time, this person is going to be relying on some sort of a benefit program. Well, it may be the case that the proceeds from this settlement are going to go in a special needs trust. And why is it first party? Because the claim was filed by our disabled individual. There's a key, now whether you see this as a downside or not depending on your perspective, but it's important I highlight the third bullet point here. If it's a first party, if it was my money to start with, part of the reason part of federal law is in the trust, it has to say that if there's money in this trust left when I pass, the state gets first crack at being reimbursed for whatever they paid for my benefit. So whatever they paid out in my benefits while I'm alive, they use the money to get reimbursed. But they are only allowed to take whatever is sufficient to reimburse what they paid for me. So I'm entitled to name the contingent beneficiaries are anybody of my choosing, family members, for example, after the state. So that's a key element, and that's part of what has to go in a special needs trust. If you ever hear, sometimes you'll hear this trust referred to as a D4A trust, D4A. All that that's referring to is that's the part of the Social Security Act that basically created this type of an arrangement. So that means the same thing. Now, the next slide, a supplemental needs trust. Some people use these terms interchangeably, but largely what we're referring to here is a third party. So this is somebody else's money. This is my nephew has had some kind of a condition his whole life where he will never be able to work. And I would really like to leave a little something for him, but I don't want to overturn that apple cart. I don't want to mess things up for him. So if I die and he gets an inheritance from the estate of Uncle Jeff, it's going to mess him up. So what I might do is create a third-party special needs trust, which may refer to as supplemental needs, which is very similar to the last one, but one big difference is there is no state payback after death. Because he was never entitled to my money in the first place, I'm not obligated to say anything has to go to the state. I could say 100% of what's left will go to whatever contingent beneficiaries I've decided to name. Now, one of the key takeaways here is there's going to be a lot of verbiage inside the trust that says not only what the trustee can do with the money, but also things that they're not supposed to do. What's an example of that? Well, if you've ever heard of SSI, Supplemental Security Income, that's a particular kind of Social Security program that's paid out to very low-income people. And SSI, per its own rules, says they will reduce the benefits if somebody else is paying this person's rent, their housing. So a third-party special needs trust might say to the trustee, I want this money to be used to supplement the needs of nephew, but not to supplant, push aside the benefits. And I might say, I don't want the trustee paying for nephew's rent. Why? Because I already know nephew is collecting SSI. Nephew has a government program that's paying for his rent. So here it's important that this document says the trustee cannot pay for rent for that reason. Now, somebody here said here, why must the special needs trust be registered with the state attorney general's office? Well, we have to sort of consider for a moment the context. Sometimes we have a situation where somebody, the beneficiary, already has a conservator. And a conservator, if you're not familiar, is a little like a power of attorney, but that's set through a formal court process. So the court sort of already has jurisdiction over this individual. And the reason why the Attorney General's office has some say, whether we need formal permission or not, even if in a given situation we don't need the state giving formal permission, we still have the language we use in trust very mindful about what are the picky things the state might complain about. And the whole reason why is because one of the many things the Attorney General's office does is some sort of indirect oversight about when the state has the right to get reimbursed. But I'd like to point out that everything I'm saying about the third party means we don't need the Attorney General's office blessing. And there's sort of a lot more freedom in that regard, if that makes sense. So that kind of really quickly is first party special needs trust, third party, aka supplemental needs trust. Now, next, sorry, I jumped ahead here. Instead of a revocable trust, sometimes we may have a irrevocable trust. And in our practice, we have a lot of older clients that are wanting to protect their home or other assets, shield it from Medicaid long-term care. So the type of trust we often will use for that, we call a Medicaid irrevocable trust, a MIT. It is irrevocable. Happening with the assets. And I'll come back to that in a moment because that's our second bullet point. But suffice it to say, the document itself is kind of etched in stone. Now, think back to my triangle. Unlike the revocable trust, where I typically will say most revocable living trusts, most clients, they create it. At least initially, they're their only trustee, or maybe a joint trustee with a spouse, and they're the primary or maybe the only beneficiary. So they're all three ends of the triangle. That's why we have so much control over this. Here, my client, the one who wants to protect her home, she's the grantor. She's the top of the triangle who created it, but she is not a trustee. Somebody else needs to be trustee. In fact, we're a little prudent. In fact, we'll put into the document under no circumstances could she ever be trustee. Why? Because we don't want the state to ever get wind of this arrangement and think the person kept too much direct control over the asset, over the property. Same thing with beneficiaries. Every trust needs beneficiaries. So typically she'll name the kids as beneficiaries, and it will be prohibited for her ever to be a beneficiary. We need to sort of separate this wall. We need to sort of make the state convinced that this asset is not in her wallet. There's other things that are in her wallet. She has her bank account. She has her retirement account. She's controlling all this. But what we're putting in this trust, it is not her resource. The name of the game is protecting it, trying to shield it. Now, we do need to be mindful that this type of strategy is very good and very smart to do, but we always have to remember there's a 5-year look back period for Medicaid. Medicaid is going to scrutinize when somebody applies for Medicaid. the state of Connecticut is allowed to look at all of their financial statement, a whole financial snapshot, and complain if they gifted away assets in the last 5 years. The way we use these trusts, because our client is not a beneficiary, it operates just like a gift, exactly as if you handed money to somebody. So we're very mindful of the 5-year look back period. But if we think the person's pretty healthy, or maybe they're marginally healthy, but they've got enough money that we think it's a good chance they can make it 5 years without needing Medicaid, this might be a good strategy for them. But I do want to just emphasize with this type of planning, we put very skillful provisions inside the trust where you can keep a lot of indirect control. For example, even if you cannot be a beneficiary, you could change and replace who the beneficiaries are. One quick example where that really came in handy. I met with a couple years ago, and they put their home in this type of a MIT, Medicaid Irrevocable Trust, about 6 years ago. So they're not worried about the home being vulnerable to Medicaid anymore. The bigger problem right now is their daughter who's getting divorced. Daughter was named as trustee, daughter was beneficiary, and the divorce is looking ugly. And the concern is, what if our soon-to-be ex-son-in-law's divorce lawyer reads this trust agreement and thinks a portion of our home is going to get sucked into their settlement over here? So what did they do? They exercised their power, called the power of appointment inside the document, to remove her as beneficiary. They would not have been able to do that if they did what some people do, which is I'll simply give the house to my daughter. The daughter, they could not have made that change otherwise. So that's just an example of that. Somebody says, is there anything you can do if they're already on Medicaid? In and of itself, that question, it's hard to answer. What I will say is Medicaid can vary a lot. Sometimes Medicaid, we have somebody who is in a nursing home and all they have left is one bank account with a tiny bit of money left. Other times, Medicaid may be somebody who's living at home and they still own their home. And it maybe we could make some changes or not, but more often what happens is we may have a situation where it's a married couple and one of them is ill, they end up on Medicaid. The healthy spouse may have some planning options, but that whole arena is very complicated. So let me move on here. So when we think about trustees, who should be a trustee? Well, right off the bat, there are sort of pros and cons, risks of various decisions. One choice is a family member. I'm going to name my spouse. I'm going to name my brother. I'm going to name one of the kids. Versus an independent trustee. I'm going to try to name our accountant. I'm going to try to name our financial advisor. I'm going to name the law firm. I don't necessarily know until I meet with a family which is the bad or bad. Sometimes I'll meet with a family to say, well, we have 3 kids, but we're concerned if we name any one of them, the other one's going to get resentful. Or they may say, well, I have 3 kids and my daughter's an actuary. She's brilliant. She's crazy sophisticated. We have the utmost confidence. There's no problem. She'll be able to be trustee for us. Well, fine. Then that's perfect. It's not a foregone conclusion whether a family member is a better choice versus an independent. Sole trustee versus co-trustees. Is it better to hire one babysitter or more than one? Well, there again, if I have 3 kids that don't get along with each other, well, then that would be a terrible choice to name all 3 of them. But then maybe they don't get along so much that I'm worried about naming any one of them. Or flip it around. I have 2 sons, they get along great. They're both capable. I think co-trustees make sense, so that way nobody's overburdened. You also as we say in the next bullet point, we think about a succession plan. Maybe my revocable trust is going to say the only trustee from day one is Jeff, but then later on the backup choice is my daughter. And maybe if she can't do it either, then maybe it's my brother. You can name a number of successors depending on what happens. And this last one, this is an important point, removal mechanisms. Nobody should have permanent job security. The document itself should build in some mechanism for removing and replacing. If I have 4 kids and I name one as trustee, and 4 years after I've left the earth, my go-to person is really exploiting the situation, well, the other one shouldn't be stuck. There should be some mechanism, kind of checks and balances, to remove and replace the person I named, but maybe within guidelines. So maybe what we say is to my other children, look, you can remove your brother, but then you have to find an independent third party. So you're not pushing him out, but naming yourself. Again, thinking in terms of kind of checks and balances. Some more attributes to think about. Some trusts are specifically intended to end when I end. It's a basic trust. It's designed to avoid probate. Once I die, hopefully it accomplished that task and it's no longer needed. Other times, thinking about my family, my beneficiaries, maybe I'm creating this trust not because of my problems, but because of my beneficiaries' problems. My son is 22. He's spending money foolishly. Why? Because he's 22. There's nothing wrong with him. He's just immature. And maybe I say, I would feel better putting an arrangement in place. If something happens to me sooner than I intended, maybe I want an arrangement where somebody else has got his checkbook and is divvying out money to him over time until he hits age 30 or 35. That's an example. Or maybe I'm not worried about my daughter, I'm worried about my son-in-law. My son-in-law is kind of overbearing, and I think he is making, my concern would be if I don't have a trust, if she just gets her inheritance, he's going to grab it. So maybe I want some sort of a mechanism in place for that. Or maybe even I'll put a mechanism where I'll leave something for the direct benefit of my grandchildren, so that my son-in-law can't get at it, but somebody can send it directly to the grandchildren. And here's where I'm talking about problem beneficiaries: substance abuse, alcoholism, immaturity, basic liabilities. Maybe my son is in a high-risk profession. My son is a physician, and he had a couple of malpractice issues. And not that he's a bad physician, but physicians tend to attract unwanted attention. So maybe that's why I put that in place. Different trustees for different assets. We can make this arrangement very complicated, but what if, let's say I'll make this simple. Let's say I really have 2 big assets. I've got my home and I got a big investment account. And my son is a contractor or property. He literally works as a property manager. So he would be a perfect candidate to manage the property the trust owns. But my daughter, she's the financial whiz. She's the investment advisor. How about she is the trustee as far as the investment part of the portfolio? So I could deviate this. What if I have 2 pieces of real estate? One's in Connecticut, one's in Maine. And lo and behold, I have one child lives in Connecticut and one lives in Maine. Well, maybe that's an arrangement where I say the local person in Maine is going to be on site easier. So I set it up that way. I have a lot of possibilities. And that's sort of my different trustees, different assets. Investment decisions versus distribution decisions. Now, this is interesting to think about because how the investments are managed, whether the portfolio is going to be an IBM stock versus Bitcoin or something, those set of decisions are not one and the same for who's decided that the trust is going to write a check to me as beneficiary. These may be 2 different things. So I might want a situation where I say, you know, my son, he has a mania for investments. He reads up all the time. I want him to be able to manage the investment decisions of his trust. But I'm worried that he's only 25. And if I hand him the checkbook, he may use the checkbook to blow the money. And the money may be gone by the time he's 40 and kicks himself and says that was a foolish decision. So maybe I'll say he gets to manage the investment aspects of his trust, but maybe his uncle is the one that formally makes decisions. And this last one, this is kind of the same as we said before, family members versus professionals. There are some families out there that will pick us, for example, to be trustee. Not that I always tell people we should be your first choice, but some families we're your only choice. And sometimes we're a good choice because we could say, I want to avoid the kids fighting with each other. So maybe I'll name the law firm because they're uninvolved. Other families, that's not a concern at all. You know, that special needs trust arrangement. If I have a disabled child and a healthy child who's more or less been helping her disabled brother his entire life, well, then maybe it's not onerous at all for me to ask if she's willing to be a trustee. But on the other hand, family members, sometimes it's hard for them to say no. If I'm putting this in place because I'm worried about the money being spent foolishly, sometimes it's harder for siblings to say no to each other. Or I may be sort of setting an arrangement where it's likely that they will have conflicts, and I want to avoid that. So as far as what powers and authorities the trust can include, well, in 2020, first of all, Connecticut has had a trust code for decades. But then in 2020, they passed what's called the Uniform Trust Code. Whenever you hear the word uniform in the law, what it means is some academics out there have cooked up sort of a model sample rule, and they've gone to all 50 states and said, you know what you guys should do in fill in the blank state? You should adopt our model rule because look how great it is. Well, this uniform trust code is going to look similar to the uniform trust code that some other states have adopted, but also with some differences. And a lot of what the trust code says you don't need to worry about, but there are some differences, some very key differences. One big difference is, for good or for ill, supporters of the Uniform Trust Code like the idea of forcing a little more information transparency between trustees and beneficiaries. They want to make sure there's a minimum amount of information the trustees have to send to the beneficiaries. Now, right there, I'll stop. And if you want me to know, is that a good idea or a bad idea? It's situation dependent. If I'm representing the uncle who was asked to be a trustee for 10 years because his nephew is immature and a black sheep and creating problems, well, I might, if I'm the uncle, I might want to tell the nephew as little as possible because of the reason for the arrangement in the first place. But now flip it around. If I, as an attorney, am being asked to represent a beneficiary, and the beneficiary says, you know, when my mom died 3 years ago, there was supposed to be some trust my uncle was managing, and he hasn't told me anything in forever, and he doesn't return my phone calls. Well, now I might say, oh, this is great because look at what the trust code in Connecticut says now. We can send your uncle a nasty letter that says, per the statute, you need to give a lot more information than you've been sharing, right? So that's sort of depending on the situation. Independent trustee, the concept of an independent trustee is sort of saying sometimes we need somebody with a different standard of discretion to make certain transactions that the regular trustee can't do. This is something that sometimes we build into our Medicaid irrevocable asset protection trust. And this last one I'll just touch on very briefly. Should there be a trust protector? Trust protector is something that doesn't officially exist as far as the state statutes are concerned, but it is something that in common law, a lot of states will recognize. And it's sort of another entity, a little hard to describe. It's somebody that's not a trustee and not a beneficiary, but it may be given certain powers and authorities. For example, we might have a trust protector that could step in and modify language in the trust after it's become irrevocable if it turns out there was a mistake, something was written the wrong way. So a trust protector can be it's a complicated topic, but it can be another tool for possible extra sort of administrative oversight. Somebody here wrote a question. I don't know if I can answer this precisely. They said, have recent changes in the trust laws made it now recommended to do an asset protection trust for an ill person or spouse? And it sounds like somebody might have talked to our firm before and somebody has a degenerative disease. Well, one thing I guess I need to be very careful about is when I do a talk like this, I can't give anybody specific advice about your own situation. This is kind of for general educational purposes. What I will say we need to be mindful of is if we have somebody that we think might need Medicaid, we need to be very careful about that 5-year look back period. And sometimes there's strategies that I might recommend somebody does, but only if I think we have 5 years to work with. And if I think that the degenerative condition is such that maybe we only have a year or two to work with, there may be strategies off the table. So to the person that asked, I know it doesn't answer your question, but I would need to know a lot more about the scenario to actually, advise on things. If I come to, okay, so I very quickly talked about this uniform trust code. It's interesting, January 1, 2020, there was a lot going on. We passed the Uniform Trust Code. It was also the time period that Connecticut switched to mandatory filing for the probate courts. Almost everything we found now is electronic, which is nice and simple. It's also when they passed the Secure Act. That was a whole big set of legislation that changed the retirement rules. There was also this little thing called COVID that came in along there. So there was a lot going on at the same time. So a lot of what the Uniform Trust Code says you really don't need to worry about. A lot of it is just sort of putting in a more organized fashion what the trust laws have already been. And by the way, down at the bottom here, the Uniform Trust Code says that it applies, well, okay. It says it applies to all trusts except certain of the more important requirements we're worried about only pertain to trusts that become irrevocable after 1/1/2020, which means either somebody has signed a document after 2020 that says, hey, this agreement, this trust is going to be irrevocable, or it's a revocable, but now the grantor has passed away. The confusing thing about that second one, though, is this may be the case that somebody created a revocable living trust in 1995. No, that's too far back. 2019. They created a revocable trust in 2019, and now 15 years later, they pass away. That trust is not going to say anything about the Uniform Trust Code, and it's not going to say anything about these hard-coded requirements of the trustee having to inform beneficiaries in a certain way. So when we have clients that have a revocable trust and they come and meet with us, this year, for example, we might recommend you do an amendment so that this document is now going to have some verbiage for the trustees to be mindful of. Because the problem is the Uniform Trust Code says when it comes to notices and accountings to the beneficiaries, it's not contingent on what the trust says. It's a requirement of state law. So there's trustees out there that when you get to the point of it becoming irrevocable. Now, I may have a revocable trust that's still revocable for 30 years because I'm still sitting here living my life. But later on, there may be some confusion as part of this. And at that point, it's important for the trustees to know what they're doing. And the other part of that, the notice requirement shows up in two different ways. We have a one-time notice. The trustee has to tell all the beneficiaries, hey, by the way, Uncle Tim created a trust. It's the so-and-so trust. I'm named as trustee. Here's my address. And by the way, Article 5A says you are going to get a 1/4 interest in what's in this trust. It says that I, as the trustee, have to make the beneficiary reasonably informed of what the trust says. Now, what does that mean? Well, maybe it's sufficient that I say to nephew, child, you're getting 1/4, but it also, I have to make them available to have the whole trust agreement. It doesn't say I have to give them the whole trust. It says they have a right to ask for the whole trust. And if they ask, we have to give it to them. Now, I can think of some families where right there that may be troublesome. Maybe I have 3 kids and I have very compelling reasons to treat them all differently. Maybe one of my kids has some very dire financial problems that's a closely guarded secret, and I don't want anybody to know, and neither does she. So she's down on her luck, but that's kind of our secret. Maybe I have another child who married a spouse who's an extremely high-paid brain surgeon. They're raking in millions. They don't really need much money, but nonetheless, they may be a little offended if I tell that child you're getting less than 1/3. Why? Because child A needs it a lot more. And maybe the third one's right in the middle. So my point is, it would get a little cumbersome, but maybe this client with these 3 children in very different circumstances, they may want them not only treated differently, but in a way where none of the 3 know that from each other. So that's an example where I might think very conservatively about one trust for all 3 of them. I might even go so far as to create 3 different trusts that say something very different, but none of them are going to know what the other trust says. And I'm creating kind of an exaggerated reason because there may be reasons why we want to stay very mindful of them not knowing what the other ones say. Hope that makes sense. Now, as far as fees, can a trustee be paid for their work? Well, absolutely. A trustee is a fiduciary. If you've never come across that name before, that word, a fiduciary is a fancy legal term that basically means it's a position of legal trust and responsibility. An executor of a probate estate as part of somebody's will, that's also a fiduciary. So fiduciary is entitled to reasonable fees. What does that mean? Well, I like to joke, whenever you hear the word reasonable as used in the law, it means people may differ. People can and will fight over it. What the trustee thinks is reasonable, what one of the beneficiaries thinks is reasonable, and what the judge thinks is reasonable may be 3 very different things. This reference here to the Hayward case. Well, believe it or not, in 1922, there was a Connecticut Supreme Court case. I think the case itself was fairly boring, but the judge wrote a really good opinion. And the judge said, well, here in Connecticut, we judge reasonable fees according to these factors. And it's things like, what was the size of the estate? Was there a special expertise needed? Were there unanticipated complications? So to this day, if a judge writes, a probate court judge writes a decree on whether or not fees are deemed reasonable, you will still see them talk about the Hayward factors. So this is another thing where sometimes I have a client who's a trustee and they will tell me, I don't want to collect a fee. And if it's the beginning of them taking over, I always say, well, hold on, not so fast. You're saying that now, but maybe a year from now, when we finally wrapped up mom's affairs, you might reconsider. You might say, boy, that was a really onerous task. I had to do a lot of hands-on. I went to the house. I had to literally slog through a bunch of boxes. I had to deal with a bunch of financial institutions. It was a mess. I had to take time out of my own job. And that's where I might be the one to say, you should be compensated for what you're doing. Other scenarios, you may be a trustee, but it's all an investment account. I hardly did anything. That's why Connecticut doesn't want a one size fits all. There are some states out there, California, for example. I could be mistaken, but I've been told California will tend to publish a schedule, a list of percentages. They'll say to all executors, maybe they say all executors or trustees, you get 1%. Connecticut doesn't do that because the idea is it should be scalable depending on what the workload really looked like. My last slide here, and we've got 3 minutes left. So actually, by my standards, we're not over. Normally, I'm very long-winded. So as far as duties, it's important to not minimize the fact that a fiduciary is a position of legal trust and responsibility. Somebody has agreed, going back to my cheesy story, somebody's agreed to follow the instructions I left on the fridge. And if they fail to do that, if they don't secure the locks, if they give the dog the wrong food and the dog becomes sick, in my little metaphor, if you will, they can be held accountable. And that's referred to as breach of fiduciary duty. So here's a few of these duties. What is duty of impartiality? Well, if I am supposed to give 1/4 of the income to myself and my 3 siblings, and I think my 2 sisters are marvelous, wonderful people, but my brother's a jerk. If he's named as a beneficiary, I cannot say I will give my sisters a distribution, but he can pound sand. I'm not allowed to do that. Because even if I don't like him, while I'm wearing my hat as trustee, I'm bound with what the document says. That's impartiality. Duty of loyalty. How about dad died, dad's house is owned by this trust, and I'm the trustee and I have to hire a lawn care company. But the lawn care company that's owned by my college buddy charges twice as much as the other one in town. But I want to do my college buddy a favor, so I'm going to hire him. That's duty of loyalty. I should look at this objectively and say, sure, I'd love to give business to my friend, but he's far too expensive. Now, maybe just because the vendor too is cheaper, maybe there's other reasons, but the point is, I need to be objective about this. And as far as administering the trust properly, there's all sorts of things that the trust might say has to be done or cannot be done. Maybe the trust says, I don't want any trust assets in mutual funds because I don't trust them. Well, then I, as trustee, even if I'm a professional financial advisor and I say, you'd be foolish not to invest in mutual funds, I can't do that because the trust says I got to do this or not that. Maybe the trustee says I have to sell something. Maybe the trust says there's a formal process where all 4 of the kids are allowed to put in a bid to buy it. And then I have to take the highest price. Again, there's a lot of restrictions here. And of course, we're following the Uniform Trust Code. So that is 3 o'clock on the dot. I don't know. We had a few questions along the way. Somebody asked here, what does a trust cost? That's a hard thing to gauge. What I will say that I think is fair to assess here is as a firm, when we meet with a new client, we put quite a bit of time and effort into it. Our first meeting is typically a good hour and a half. So we tend to charge a consultation fee. Our standard consultation fee is $475, but if anybody wants to meet with us about their individual circumstances, make sure you tell them you saw this webinar because they shave $100 off that cost. And there's no guarantee that anybody's going to hire us for anything beyond that meeting. Sometimes I meet with people and it's literally a one-time advice session. So other than that, it's kind of hard to gauge what we're looking at beyond that. And one takeaway from all this, by the way, is just because I've told you an hour all about trust, I can't tell any of the people in the audience you need a trust for certain. You may not. There's plenty of people out there that you don't need a trust at all. You don't have any of the circumstances we look like. That's why there are some firms out there that tell everyone you need a trust. But I come back to my basic, simple idea that a trust is a tool in the toolbox. And like tools, some tools are important for jobs and other tools are not good appropriate. Somebody said, can a home be in a trust? Absolutely. A home can be a trust. I think one of the things with your home you need to gauge is circling back a little bit. There's a very big difference between that revocable living trust and the Medicaid irrevocable asset protection trust. They're similar as in you can think of the triangle for both of them, but they're also kind of opposite each other. Because the revocable living trust, I am maximizing direct control. I'm still in charge. I have the right to change it. Nobody's going to limit my access to it. The irrevocable trust is just the opposite. I'm very carefully putting it beyond my direct control. Why? Because if I run into Medicaid, I can quite validly tell the state, I don't own that home anymore. 6 years ago, I deeded it to my son as the trustee. So look, if you want to know about it, ask him, and they wouldn't have a right to ask him because the trust is none of their business. So coming back to my basic idea, the home can be owned by a trust, but as far as which trust, if any, makes sense to you, totally situation dependent. So thank you everybody for coming. Hopefully you learned a little something. If anybody has other questions that we didn't answer, I'm pretty busy, but I don't mind if you want to email me, and if I can give you a nice simple answer, I'll try to. Certainly I'm more than happy to meet with anybody that wants to, and if not, no problem. Hopefully again, you know a little more than you did an hour and 4 minutes ago. All right. Thank you, everybody. And I hope you all have a great rest of your summer. Take care.